Hi guys, I'm Advocate Khosan Rani and I'm here with another episode. Today I'm going to teach you all about sexual harassment and the laws prevailing in India at the time of making this video. Uh, it's important to know that sexual harassment laws in India are at the very nascent stage. They've been recently enacted as latest as 2013, and prior to 2013, amazingly, uh, we did not really have legislation in place, but we had a law for the purpose of Article 141 of the Constitution, where the Vishakha case created some guidelines. So the Vishakha case of 1997 laid out 9 guidelines which determined how employers and employee relationships were to be governed, and it was focused on women's rights. And uh, the reason for this, if we see the detailed judgment written by the Chief Justice, the then Chief Justice, Justice B.N. Kripal, and along with Her Lordship Sujata V. Manohar. So, if we see what was going on in that judgment, the Vishakha case was Vishakha is a NGO that had filed this case on behalf of a female employee social worker who was unfortunately gang raped during her employment, and during her it's part and parcel of the criminal proceedings, which one can always look up on the internet and go through the details about it. In the Vishakha case, a number of the articles of the Constitution were looked into. Article 14, Article 19, Article 21, Article 42, Article 51, Article 51A, Article 253, and the 7th schedule, of course. And along with this, certain international treaties were looked at. So, what is the importance of this judgment? This judgment, like I said before, created guidelines in a time when no legislation or law existed with regards to sexual harassment at workplace. It was the need of the hour. Uh, so, the Constitution has created a lot of duties and a lot of responsibility on the government. As we are aware, India is a welfare state. What that means is that the government is not only in charge of maintaining an army, but the government is also in charge of looking after the country as a community of people. And when such responsibility comes, the government needs to work as per the basic structure of the Constitution. And what if you see the language, it's not a direct hit. There's no direct legislation powers given to the government for the topic of sexual harassment, for the subject of sexual harassment. The way legislation has come about for sexual harassment is through the use of number one, Article 141, which is law. Any order of the Supreme Court is to be deemed law of the land, and so it first of all, the first law of sexual harassment came through the judgment and through in the form of guidelines. Some might argue that this was an overstep taken by the Supreme Court, and the doctrine of separation of powers, as we all know, could be brought into this. However, the Supreme Court also looked at the Beijing Law Asia report, in which the objects of the judiciary is to ensure that people can live securely in the country and live by the rule of law. That human rights are to be guarded by the Supreme Court, by any judiciary. Human rights are to be guarded, and there should be no law impartiality. So looking at this, the Supreme Court believed it was its responsibility and its duty to ensure that there is no that every person is subject to the same law and every person is protected. And and looking at articles 14, articles 19 1g, article 21, we see that the constitution itself is in its own way has already accounted for sexual harassment. However, this was against this part of the constitution, part 3. It is fundamental rights, and fundamental rights are only against state action. But if you extract the fundamental duties, and if you look at 51A particularly, which talks about 51A is the fundamental duties, in which it is mentioned that the state should ensure that no person continues to profess or practice anything that is derogatory towards women. So in a way it was a function, it was a duty of the state to ensure that there is law on this aspect, and that nobody is doing such acts which are offensive or which demote women. Moving ahead from this, Article 51 clearly mentions that the government has to promote international peace and security. Within this article, it is clearly mentioned that India requires to respect international law. Now, as soon as this comes in, we go to the Convention on Elimination of All Forms of Discrimination Against Women, which was in Beijing. And in the Fourth World Conference on the same topic, India had ratified, had basically accepted this convention. That was in the year 1993, I guess, and 25th June 1993. Now, what happened in that convention was that a set of guidelines and a set of rules and regulations on how sexual harassment can be tackled at workplace were also placed within those conventions. Now, since India was a signatory to it, by virtue of Article 253, India had competency, the Parliament had competency to create laws on these topics, and by virtue of schedule 7th schedule, the Union list 1. So by virtue of this, the government had the competency, the Parliament had the competency to create legislation. However, no legislation had come out since 1993 to 1997, till this judgment was, the Vishakha judgment came out. There was no legislation. In 1997, the Supreme Court recognizes this legislation capabilities, competency, and goes ahead and keeps a temporary law in place under Article 141. And this guidelines is eventually considered in the 2010 Prevention of Sexual Harassment Bill, which later takes the shape of the Sexual Harassment at Workplace Prevention Prohibition Act of 2013. So let's just have a small infographic discussion on this topic now. Let us take a quick recap into the timelines of the Sexual Harassment Act. So prior to 1997, there was no law at all on the topic of sexual harassment. Then in 1997, the Vishakha and others case led to the formation of guidelines which became the basis of our present act. Along with these guidelines, the Supreme Court order authored by 2 Supreme Court judges laid down directions that the central government takes cognizance of the lack of legislation in place on the topic of sexual harassment. This led to the bill, the first bill, which was approved by the Union Cabinet in the year 2007, roughly 10 years after the passing of the Supreme Court's directions. Then later on in 2010, this bill got introduced into the Lok Sabha. However, it did not get passed into legislation, and in 2012 it was reintroduced into the Lok Sabha. At this juncture, the bill's name had been changed, and it took the present name. It was later in the fag end of 2013 when the bill was passed into law, and practically the guidelines of 1997 were in totality adopted by the legislation, and not only were they adopted, but more intricate details were thought out, and more technical aspects were dealt with, and we have the present act, which was with the rules, which was in the fag end of 2013. Moving on, the first definition that we look under the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act of 2013 is Section 2A. Section 2A deals with the term aggrieved woman. What the word aggrieved woman means is it's a very wide term in respect to this act, and this term includes any woman, whether she's employed or not employed. And what is important here is that it should be in relation to a workplace. The word workplace itself is also defined in this act. Now, any woman who alleges to have been subjected to any act of sexual harassment, which again is defined by the respondent being also a person defined who the complaint is registered against. This act basically covers all sorts of people. It covers maids, it covers freelancers, it covers potential employees, it covers any female who enters a workplace, and it protects her. And thus the crux becoming in relation to a workplace. Now, moving on to the next definition, which becomes crucial, is the term sexual harassment. What is sexual harassment? And in this, the key term is any unwelcome act, or rather the following unwelcome act, which is again an exhaustive list of 5 entries, and these 5 entries are extremely wide. So it is absolutely pertinent for the employer and all employees to be very well aware of what could be construed as sexual harassment, which could be almost anything. But the major essence of the sexual harassment is that it requires to have sexual nature in it. So any physical contact. Now, the first category is quite wide. It is simply any physical contact, unwelcome physical contact and advances, or it's also any demand or request for sexual favors. Now, first one is any physical contact, okay, which is unwelcome, is sexual harassment. Any physical advances, which is unwelcome, is sexual harassment. Any demand or request for sexual favors is sexual harassment. Any sexually colored remarks is also sexual harassment. Any act of showing unwelcome, remember the word here, I cannot stop to emphasize, but the key words here is it has to be unwelcome. When I mean what I in layman's terms would imply when I say unwelcome, would be any resistance to the act would be a unwelcome act. Any act which is taken openly and which is accepted openly is not an unwelcome act. Therefore, only unwelcome acts are prohibited by this law, nothing else. Therefore, the fourth category is showing of any pornographic content, unwelcome showing. And finally, any other unwelcome physical, verbal, non-verbal conduct of sexual nature is sexual harassment for the purpose of this act. Moving on, what becomes very crucial here is the employer's duties. Now, the employer's duty, as per the purview of this act, which has got serious repercussions for the employer, the breach of these duties has got a serious repercussion, legal repercussion for the employer. And first, I'll discuss the duties. The duties include he needs to ensure that there is a safe work environment. Okay, he needs to ensure that people are well aware of sexual harassment. They're well aware of what constitutes sexual harassment. They're well aware of the consequences of sexual harassment, and he is also in charge to ensure there's a mechanism in place as prescribed by the Act for redressal of any complaints of sexual harassment. Now, moving on to the punishments. Also, he's supposed to assist and make sure that this machinery put in place by him, is functional. He has to make sure that it's working. It's his duty. And in case of any breach of these duties, he could be liable to up to 50,000 rupees as a penalty for the first offence, and for the second offence up to 1 lakh rupees as penalty. And also he could face cancellation of any government issued licenses or any cancellation, withdrawal or non-renewal of any licenses. Therefore, these have serious implications. It could shut down his business. It could literally shut down his business in addition to a fine. I don't think the fine becomes a major component for the big companies, but what becomes a major concern is that their licenses could be revoked and they could be shut down. Therefore, this becomes a very crucial act for the employer. Now, moving on, we see this internal committee, complaints committee. This internal complaints committee is one of the most crucial parts of the Act. The Act envisages creation of an internal complaints committee, which, as it sounds, is basically a committee created by the employer, and it's for receiving complaints of the employees in that particular organization. Now, it's the duty of the employer to ensure that this committee is formed. Not only is it his duty to ensure that it is formed, he needs to ensure that it is situated at all his offices, all his administrative offices, no matter where they are in the country. It has to be established in each office, and each committee needs to have at least 50% of the committee members should be female. Now, there are certain more specific criteria. For example, the presiding officer should be a senior level female officer. Therefore, she should be of a high rank, and it has to be a female, the presiding officer. And if a presiding female officer of a high rank is not available in one office, it's not mandatory that the employer now goes and hunts for a female employee to fill the position. He can have male employees, that's totally okay. However, then in that case, the presiding officer from another, a female high-ranking officer of another office would be eligible to be made into the presiding officer of the internal committee of another place, another office. And in addition to this, supposing there is no female high-ranking officer, then high-ranking employee, then what happens is the employer is at the liberty of selecting any other person. However, he has to maintain the 50% of the members. Now, in total, I believe there is 1 plus 2 more other people, no, 3 more other people. So there are 4 members. So therefore, in total, 2 of them need to be female. 1 is supposed to be the presiding officer, unless there is no female high-ranking employee. Then in that case, it can be a male. But the other 3 have to be 2 have to be female. Now, 2 members among the employees have to be preferably who are committed to the cause of women or who have legal knowledge, should be made as the other members of this committee. And finally, 1 member who is from a non-governmental organization or association committed to the cause of women. So, or also maybe who is familiar with sexual harassment laws. So as long as this criteria of one half women being female is met, and the committee comprises of these 4 people, with one person being the presiding officer, who generally should be a woman, is if these conditions are met, then the employer would be said to have constituted the internal complaints committee in compliance with the act. Else he would not be in compliance and would attract legal repercussions as mentioned earlier. However, supposing the employer does not has less than 10 employees. Now in such a case, when he's got such a small workforce itself, to set up such a committee might not be feasible or might not make sense, because it is a extremely small firm or organization, and therefore in such circumstances the law is a little relaxed and the employer need not create this committee. However, there is a local complaints committee to be established. This local complaints committee is established in every district, and it is also got a district officer who is the person who is in charge of ensuring that the local complaints committee is set up to receive these complaints, and basically this local complaints committee becomes similar to the internal complaints committee. Moving on, how are these complaints to be made? By whom can they be made? To whom are they supposed to be made? And when are they supposed to be made? So first let's tackle when. These complaints are to be made within a period of 3 months, that's 90 days, from the date of the occurrence of the incident. Now if the incidents are multiple, then from the last incident, the 90 days would start. The principle behind this is basically that a person should be vigilant and should exercise his right within a certain period of time, otherwise it is presumed that the person has waived his rights. Therefore, a person who sleeps on his rights does not have any rights after a certain time. His rights get exhausted. Now, supposing for whatever reason a person is unable to file a complaint within this period of 90 days, within this window, then it doesn't mean his rights are immediately exhausted. He is given a second chance and he is permitted to file it within another 3 months, therefore a total of 180 days. However, he needs to explain why it could not have been filed in the first period of 90 days. Therefore, that explanation is called a condonation of delay application or a condonation of delay request. This request is it puts before the committee to decide whether they were justified in the delay, and in case they are found justified, then the complaint should be accepted. The general thumb rule that is followed, which is a thumb rule, which is no law as such, but the thumb rule is that the delay should be condoned because it is in the interest of justice that justice be met, and therefore it is it's always recommended that the delay be condoned. However, if it goes beyond 180 days, there is no prescription, you have waived your right, you cannot go before the forum. It's beyond the condonable time. So my recommendation and advice to every person who is a victim of sexual harassment is make the application as soon as possible. And the next thing, by whom can these complaints be made? These complaints are to be made by the aggrieved woman who we discussed in the earlier slides, by the aggrieved woman. Now, the aggrieved woman or her heirs or her relatives or her colleagues or any other such person who has been defined by the rules may make this complaint. This to whom is this complaint made? Now, we had 2 committees. One was the local complaints committee, which was created by the district, and the reason for this local complaint committee is because there is a lack of internal complaints committee. So wherever there are less than 10 employees, you need to make this complaint before the local complaints committee, and actually before the district officer you make it before the local complaints committee, who will then direct it to the district officer. Now, in case of the internal complaints committee, you make it simply to the internal complaints committee. You make the complaint against it to them. And how is this to be made? Well, the standard is supposed to be in writing. You are supposed to make the complaint in writing, and some cases might allow oral, some exceptions are there where oral complaints are also accepted. Once this complaint is made, the first thing the committee is going to try to do, it's recommended to do, is to try to settle this dispute, this issue. And the way of resolving this issue cannot be through monetary terms. Therefore, I cannot commit an act of sexual harassment and then pay off the victim and tell the victim, forget about it. That is not permissible under this act. What is permissible under this act is if I make an agreement with her or with the person, the aggrieved woman, and I tell her that, you know what, I'm okay with a transfer and I'll work from this department, or you know what, I would like to resign and close the matter, or you know what, I would like to apologize to you and close the matter, or any of these kind of things. He might propose a way out, and in case he proposes the way out, then no inquiry, nothing is to proceed. It's supposed to die at that. The settlement has to be informed to the employer, and employer has to take action in accordance with the settlement. He goes through the settlement, he finds it just and right, and he goes and he makes sure the settlement is made effective. However, it's important to note that the settlement cannot be on monetary terms. Now, in case no settlement is arrived at, then an inquiry has to be made. This inquiry is the power, the complaints committee is authorized to perform this inquiry in accordance with the civil procedural code, and the inquiry has to be done in a time bound manner, which is within 90 days of receiving the complaint. And after the 90 days of receiving the complaint, the inquiry has to be completed, and then a period of 10 days is given to the committee to form a report on the findings of the inquiry and also on its recommendations, the committee's recommendations. Therefore, the committee plays a dual role. The first role is a fact-finding role, where it simply collects, like an inquisitorial system, it simply collects data and compiles the data. This compilation of data needs to be unbiased. This needs to be unprejudicial. It has to be a fair compilation. There should not be only one side research done or one side work done. It has to be on both sides. It has to just collect data, just plain old collect data and present it. After that data is collected, they have to read the data and come to the conclusion of what they believe is right and wrong. So first, the complaints committee performs a simple fact-finding, non-prejudicial method of finding, and then it presents its recommendations before the employer. Once these recommendations are presented, the employer needs to act within 10 days, within 60, within 60 days, the employer needs to act upon these recommendations, and that is as far as the inquiry procedure is concerned. The consequences of this complaint could lead into three scenarios. One is an action is taken, two is no action is taken, and three is a counter case and counter action is recommended against the complainant. So the first case is, if the person is found guilty of sexual harassment, it is recommended, a certain course of action is recommended based on the severity of the offense, of the allegations. And second thing is, in case the complaint is found not really proved, the allegations are not really proved, but the allegations seem to be a little not 100% there, not fake, not fabricated, not misleading, not false, then in that case they might recommend that this does not attract any penal provisions and to drop to not take any action and to drop this matter, this complaint. And the third one is where the committee finds out that the complainant has been motivated to pass such allegations and has committed misrepresentation or falsification or fabrication of documents or information. In such a case, the committee can put penal consequences upon the complainant itself and recommend those consequences. Now, the types of consequences that can follow is either in the action part where it recommends action. The actions that can recommend is to have a written apology taken, or to issue a warning, or to reprimand or censure the person, that is, make a formal account of this offense on that person's record. So tomorrow, whenever that person goes for promotion or goes in the future to another company, this document would follow with it. So it would be a document that has now put a stain on his record. And otherwise, they can withhold a pay, a raise, an increment, or they could terminate the person from service, or any other punishment in accordance with any service rules. In case there are service rules, the service rules are to trump. And again, even in the inquiry procedure, the service rules are to trump. So in certain government offices, there are certain government service rules, and those service rules trump. Now, moving on, finally, the appeal. An appeal is made under Section 18, and this appeal can be made by any person who's aggrieved by the order of the employer. And there are certain requisites required to be achieved as envisaged under Section 18. If these conditions are met, and if this appeal is preferred within 90 days under the grounds stated in Section 18, under any of the grounds stated under Section 18, then an appeal will be maintainable. And so that's all for the sexual harassment, this sexual harassment lecture. I hope you all enjoyed it, and I hope you all make sure that any employer and employees are all made aware of this act and these rules, so that they know their rights and they do not get victimized and suppressed because of the lack of knowledge. Because ignorance of law is not an excuse in the Indian legal system. Thank you very much, and stay tuned for more.